of the people, or that the people, like, what would the people view? And in my view, the United States Constitution is a compact, and it's the fundamental law of the American people. And so I don't think it would be controlled by the laws passed by other countries, because it reflects the fundamental commitments that we as an American people have made.
Thank you very much. I reserve my time.
Senator Durbin.
No, Senator Lee.
Oh, I'm sorry. I apologize, Senator Lee. Apologize.
I kind of like to get
out of sight, out of mind. I apologize.
Okay. Thank you. Can you hear me? Can you hear me all right?
Yes, sir. Loud and clear.
Incidentally, for those who are watching and think that we may be polarized in things, and listen to what Senator Grassley said about cameras in the courtroom, and of course I agree with him on that, and he knows I have supported that. I've also joined with him on a few of the False Claim Act improvements. So there are many areas in our committee where senators have worked together. And I would ask, Mr. Chairman, if I could, unanimous consent, that a letter from 10 former federal judges who are opposed to the process of this nomination, along with letters of opposition to the nomination from People for the American Way, NARO, and 208 women lawyers, that they be inserted in the record.
Without objection.
You have to assume that somebody's going to hand you those letters. I can't quite reach from my room here. Now, Judge Barrett, it's good to see you again. I commend your children. I'm sure this is fascinating, but I'm sure it's a long day. And I'm sure you probably felt the same way, but this is part of democracy, and it's important that we have these questions. Now, we're being told that no one could possibly know how you would rule in the latest Republican-led case to overturn the Affordable Care Act. But what we do know is that you criticized Chief Justice Roberts' opinion in NFIB versus Sebelius. You stated that, quote, Roberts pushed the ACA beyond its plausible meaning to save the statute. And then you praised the dissent in King versus Burwell. So it seems every time you weighed in on the legality of the statute, you come to one conclusion: the Affordable Care Act is unconstitutional. Now, over the past 2 weeks, you provided this committee, all of us, with some 1,800 pages of your writings and speeches for us to review, and I have. Now, I may have missed something in that, but did you ever write or speak out in defense of the ACA?
Senator Leahy, I just wanted to make one correction. King versus Burwell wasn't a case about whether the Affordable Care Act was constitutional or not. That one was purely a question of statutory interpretation. So just to make clear about that.
But
I would say that
you did praise the dissent.
I did. In a radio interview, I said that I thought the dissent had the better of the statutory interpretation argument. I have a couple of things, I guess, that maybe might help shed some light on this question. One is that, of course, in both of those contexts, I was speaking as an academic. And as I mentioned yesterday, an academic serves a very different function than a judge. So an academic doesn't go through the judicial process, doesn't hear the case or controversy, have the litigants and the briefs and the consultation with colleagues, the writing of an opinion.
We all understand that, but that's not my question. My question was, did you ever write or speak out in defense of the ACA, whether as a academic or as a member of the judiciary? That's a pretty simple question.
No.
Could be answered yes or no.
No, I've never had occasion to speak on the policy question.
And so every time you've weighed in on it, you said the law is unconstitutional. Now,
No. Sorry, I thought you were done.
Well, and the court, of course, have to it's going to have to look at both severability, standing, constitutionality, and you haven't written on severability of the ACA, have you?
I have not.
Thank you. And now, here's a quote that I'm sure you're familiar with in preparing for this, and it's been used in the last few days. Quote is throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. Have you heard that quote before?
I believe that's from the dissent in Shelby County.
By Justice Ginsburg, is that correct?
I believe so.
Actually, it is. She was talking about and warning about striking down Section 5 of the Voting Rights Act. Now, Shelby County, it was almost like immediately after Shelby County came down, states started making changes. 20 states enacted new restrictions on voting. And some of those restrictions have been horrendous. Do you know how many polling places have arbitrarily been closed across the country since the Shelby decision?
I do not know, Senator Leahy.
I'll help you there. It's at least 1,600. Now, following the Shelby decision, do you know how many voters were purged from voting rolls?
I do not know.
Roughly 16 million. That's about 30 times the population of my state. African Americans with felonies are 4 times more likely to be disenfranchised than other Americans with felony convictions. Non-white voters are 7 times more likely to wait in line for more than an hour than, black voters wait longer in line than white voters. I mention this because this is a picture from DeKalb County, Georgia. Those are the lines. African Americans make up the majority. Look at that line. I suspect neither you nor I have ever had to wait in line like that to vote. In fact, the press reported that today those lines could be 10 hours long. People talked about, well, are we giving racial entitlement? This is not entitlement for any Americans. This is not entitlement. This is turning our back on democracy. This is saying you can't vote, or we're going to make it so difficult for you to vote, you can't. Harris County in Texas, which has population many times that of my state, has 1 early voting spot. People have to drive for hours and wait in line for hours to get there. Would you accept the fact, or would you acknowledge the fact that communities of color disproportionately face restrictions and obstacles when they are casting their ballots?
Senator, I wasn't aware of the statistics that you were citing to me. If it became relevant in any case that was litigated before me and was presented to me, I would, of course, have an open mind about it.
Well, I talk about this because I know you have spoken feeling much like former Justice Scalia, who I would know was a friend of mine. But I disagreed with him on many things. He talked about racial entitlement. It's not racial entitlement. when blacks have to stand in line for 10 hours to vote. And Justice Ginsburg, of course, dissented in Shelby. She knew what the consequences would be. I only mention that because it's okay for a judge not to close his or her eyes to reality. Now, I asked you last week what a Justice Barrett would do if a president or even a senator did not follow a Supreme Court decision. You declined. You said the question may come before you. I then asked if the Supreme Court would have the final word. You stated the Supreme Court would have the final word as far as the lower courts are concerned. And that surprised me, and it concerned me, and I'll tell you why. I asked Justice Gorsuch, and I asked Justice Kavanaugh those questions. I asked them what happens then, and they made it clear that a president cannot refuse to comply with a court order, and the Supreme Court's word is the final word on that matter. That's what Justice Gorsuch and Justice Kavanaugh said. So I would ask you this. Do you agree that a president must follow a court order and the Supreme Court's word is final? Or is the Supreme Court's word only final as far as the lower courts are concerned?
Senator Leahy, I'm glad to have the opportunity to clarify from our conversation. First, I know that both Justices Gorsuch and Kavanaugh said that no man is above the law, and I agree with that. But I conversed with Senator Lee yesterday about Federalist 78, which says that courts have neither force nor will. In other words, we can't do anything to enforce our own judgments. And so what I meant in the conversation with you is that as a matter of law, the Supreme Court may have the final word, but the Supreme Court lacks control over what happens after that. The Supreme Court and any federal court has no power, no force, and no will, so it relies on the other branches to react to its judgments accordingly.
I remember as a young law student having lunch. Our honor society at Georgetown was able to have lunch with the members of the Supreme Court. I sat with Justice Hugo Black. He told me what happened with Brown versus Board of Education. And the court knew that was going to be a very, very tough case. And what did they do? They waited till they had a unanimous opinion because they knew that the president would have to, and the Congress would have to enforce their law. So let me ask you this. Of course, the Supreme Court has no army. They have no force, but they do have the force of law. And is a president who refuses to comply with a court order a threat to our constitutional system of checks and balances?
Senator Leahy, I think the example of Brown is a perfect one in this instance because the Supreme Court in Brown, of course, held that segregation violated the Equal Protection Clause. That was the law, but as you know, there was resistance to that decision. And so it wasn't until the National Guard came in and forced Governor Falbus to allow desegregation that it could happen because the Supreme Court couldn't do so itself. And in Cooper versus...
I understand that, but they made the order. And could a president, if a president refused to follow what they had said, would that be a threat to our constitutional form of government?
Well, as I said, the Supreme Court can't control whether or not the president obeys. Abraham Lincoln once disobeyed an order during the Civil War of a circuit court. So a court can pronounce the law and issue a judgment, but it lacks control over how the political branches respond to it.
Well, then let me ask you a specific that has come up. President Trump claims he has a absolute right to pardon himself. Now, for 200 years, the Supreme Court has recognized the common law principle that nobody can be a judge in their own case. I had to go way back and reread Calder versus Bull to see that. But would you agree, first, that nobody is above the law? Not the president, not you, not me. Is that correct?
I agree. No one is above the law.
And does a president have an absolute right to pardon himself for a crime? I mean, we heard this question after President Nixon's impeachment.
Senator Leahy, so far as I know, that question has never been litigated. That question has never arisen. That question may or may not arise, but it's one that calls for legal analysis of what the scope of the pardon power is. So because it would be opining on an open question when I haven't gone through the judicial process to decide it, it's not one on which I can offer a view.
Okay, and so, but you were willing to say that no person, not you, not me, not a president, is above the law. I find your answers somewhat incompatible, but those are your answers. You have a right to say what you want. Now, you're an originalist. Can you explain why the framers include the foreign and domestic emoluments clause in the Constitution?
I think I could speak generally to what is the well-accepted view that the foreign emoluments clause, it's plain from that text that it's designed to prevent foreign influence in government affairs.
It's sort of the anti-corruption clause of the Constitution, isn't it?
I'm sorry, could you repeat that question?
It is sort of what you would say, it's the anti-corruption clause in the Constitution.
I don't know if I would characterize it as an anti-corruption clause. I think I would characterize it just as I did, which one, from its very text, you can see is designed to prevent foreign countries from having influence.
I was thinking what at the Constitutional Convention, Governor Edmund Randolph said the clause was thought proper in order to exclude corruption and foreign influence, prohibit anyone in office from receiving or holding any emoluments from foreign states. And now we find that 200 companies and foreign governments have patronized Trump properties. At the same time, they were getting benefits from him and the administration. First 2 years of his presidency, he earned $73 million for his properties abroad. And an originalist, as you are, do you think these companies and foreign governments would have fallen within the framers' zone of concern in writing the emolument clause?
Senator, the emoluments clause, it's under litigation. There was a Fourth Circuit case that recently involved this question. So as a matter that's being litigated, it's very clear that that would be one that I can't express an opinion on because it could come before me.
I've found it interesting what you've written about stare decisis and precedent, and it seems that you're willing to depart from it, and that's as a justice, I suppose you could do what you want, but in the June medical services, Chief Justice Roberts joined the majority, struck down a Louisiana law restricting access to reproductive services, even though he had dissented in a previous case, striking down a very similar Texas law. He said the legal doctrine of stare decisis requires us, absent special circumstances, to treat cases alike. So having been on the losing side in the first one, he took that position of that case. Do you agree that he demonstrated a commitment to stare decisis in this case?
Well, Senator, no justice that I'm aware of throughout history has ever maintained the position that overruling a case is never appropriate. As you probably know, there's a Supreme Court case that said that states could criminalize sexual conduct between same-sex couples, and Lawrence versus Texas overruled that case. Plessy versus Ferguson was precedent, and Brown versus the Board of Education overruled it. So the Supreme Court has always said that in some cases, overruling precedent is the right course for the court to take, but that it's not done willy-nilly.
I would urge you to read what Chief Justice Roberts said at the opening of the African American Museum in the Smithsonian about following precedent. I realize my time is up. I'm going to I'll submit a question to you because I wonder what restrictions you see on the President's authority under Executive Order 12333 to conduct surveillance activities that haven't been authorized by Congress. I ask that because Senator Lee and I and others have done a lot of legislation on surveillance, and now we question whether that's being ignored. So I hope you will take it as a serious question and answer it for the committee.
Thank you, Senator Leahy.
Thank you. We'll make sure that happens, Senator Leahy. Senator Cornyn.
Mr. Chairman, I'd ask unanimous consent that 3 letters I have here in my hand be made part of the record, please.
Without objection.
Thank you. Good morning, Judge.
Good morning, Senator.
I'd like to wax philosophical with you for a few minutes, and you don't need your notepad. I just think there's been so much discussion about the role of judges and the role of the political branches. I think maybe it's worth going back to first principles. And to me, the most important first principle is in the Declaration of Independence, where it says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men," and here's the most important part I want to emphasize, "deriving their just powers from the consent of the governed." Now, you and I talked a little bit about consent of the governed as being the very foundation of the legitimacy of government action. Do you agree with that?
I do agree with that.
And does that inform your philosophy when it comes to the appropriate role of judges and the political branches like the Congress?
Yes, it does.
I had the great privilege of serving on the state court bench for 13 years. And so when I came to Congress, I'd never served in the legislature before. And so it was quite an eye-opening experience for me. For example, after one vote on the Senate floor, after the vote was over, one senator got to the microphone. He said, "Now for a little legislative history." That was kind of shocking to me, but you understand where I'm getting at. And one reason I appreciate your approach and Justice Scalia's approach to statutory interpretation and emphasis on the text rather than legislative history, this is a way for somebody who lost the vote to come in and try to then tilt the scales of justice in their favor by adding some ex parte legislative history. And then imagine my shock when I served, as I do now, on the Finance Committee. When we mark up legislation in the Finance Committee, we don't actually get to look at legislative text. It's kind of surreal. They call it a notional markup. In other words, we end up voting on sort of a notion or concept, and then somebody in the Leg Counsel's office writes up the text. Very strange. And then there's this issue of, I know in the judiciary and in the legal profession generally, there's been a big movement toward plain language so people can understand clearly. You have to unlearn some of the lessons you learned in law school, particularly writing on law reviews and the like, where you are seemingly are rewarded for this really obtuse, impenetrable language, and of course, where you use Latin phrases and things like that. But the plain language movement in the legal profession strikes me as a very important movement, and I yearn for those days when perhaps Congress can embrace that so we can speak more clearly, so more people can understand and not delegate our legislative responsibilities to staff. But I also was struck by the fact that one of the reasons why cases get litigated is because of the failure of the Congress to build consensus for legislation. And to me, the Affordable Care Act is one example of that. When either side pushes through a partisan piece of legislation, it's not realistic to expect that the fight will be over. It'll just move to a different form. It'll move to the courts. That's not what happened on things like Medicare and Social Security. There was built a broad bipartisan consensus. In other words, members of Congress actually did the hard work to find that consensus so that they didn't have to hand it off to the judiciary. And unfortunately, I think we've seen a tendency in recent years to do exactly that, where Congress has abdicated its responsibilities, figuratively, let me say, pull the pin on a hand grenade and then hand it to the judiciary and say, you figure it out. And maybe, just maybe, that's one reason why these judicial confirmation hearings have become so contentious, because people actually see the judiciary as the ultimate policymaker. And as was quoted, I think, Justice Scalia talking about the value judgments of judges versus those of the citizenry or elected representatives. And he said that there's no reason to think that the value judgments of the judiciary are any better than those of the citizens that ultimately, in whom resides the ultimate legitimacy and political power. And of course, the most fundamental difference, I guess, between the job that you currently hold and the one that you will hold on the Supreme Court is the notion of accountability. As a judge, you serve for lifetime tenure, correct?
Correct.
You don't have to stand for election.
No.
You don't have to raise money.
No.
You don't have to consult polls.
No.
Focus groups?
No.
Well, how in the world do you decide a case if you don't consult with public opinion, polls, focus groups, or the like?
Well, the reason we have life tenure as federal judges is to be insulated from the pressure that such things like focus groups or polls or public opinion might, the pressure that it might apply for a court to decide a case a particular way or the other. That's why we decided according to the text.
Well, and there are various rules of the road, so to speak, for how the judiciary approaches cases, right?
Correct.
In other words, perhaps the most fundamental difference is that rather than making broad policy pronouncements, you decide cases, correct?
That is correct.
And in fact, I'm struck by a New York University Law Review article by Justice Ginsburg in, I forgot what year it is, but where she talks about Roe versus Wade. And she talks about what she called the breathtaking decision versus the court's more cautious dispositions. She said, suppose the court had stopped after rightly declaring unconstitutional a portion of the law and had not gone on, as it did in Roe, to fashion a regime blanketing the subject, a set of rules that displaced virtually every state law that enforced. Would there have been a 20-year controversy we have witnessed, reflected most recently in the Supreme Court's splinter decision in Planned Parenthood versus Casey? Might it have served to reduce rather than to fuel controversy? Well, I think what she's saying is when the courts step in and basically take over by stating a constitutional rule, it really prevents the very people who are elected by voters from making policy, correct?
Correct.
And there are a number of other things other than the requirement of a case or controversy that keep the judiciary in its appropriate lane, things like standing requirement.
Yes.
What is standing?
Standing means that you can't just come to court, say, because you dislike Senator Graham's Fetal Pain Act. You can't just walk into the door of the courthouse and say, I don't like that act and I think it's unconstitutional. Standing means that you actually have to have suffered what the law calls a concrete injury. So it has to have affected you in some way. So that means that there are real litigants with a live controversy before the court. People can't come to court to air policy disagreements only.
And then there's a requirement of ripeness. What is ripeness?
Ripeness means that there has to be a live controversy. You can't run to the courthouse door and file a lawsuit until it's ripe, which means that the injury I was talking about has actually come to fruition, come to pass.
And of course, by the time you see it on the circuit court, the case has already had to have been tried by a trial court, correct?
That is correct.
And then there's a record, right?
Yes.
And what encompasses a record that the trial court prepares that you review as an appellate judge?
Well, there'll be factual parts of the record. So if there was a trial, there'll be very lengthy transcript of that trial. A district court makes a number of legal rulings in the course of a case. So the court may have ruled on, say, a motion to dismiss and whether the law even permitted this, whether the law gave the plaintiff a valid claim. The court may have ruled on a motion for summary judgment, which means that's an evaluation of whether the plaintiff or the defendant could win the case without even going through a full trial because the law was clear enough. So there are many things along the way. There are evidentiary rulings, legal rulings, a factual record that develops, and in some instances it's quite long.
And as an appellate judge on the Seventh Circuit, you can't go outside the record, can you?
You can't. The record can't be expanded on appeal.
And that's true in the Supreme Court as well?
Yes.
And so all of these rules of the road, I'll call them, things like the case or controversy requirement, ripeness, standing, being confined to a record that is then the sole focus of an appellate review. Do all of those things, are all those sort of indications of how the judicial decision-making process is different from the legislative process?
Yes, and it can take years for a case to wind itself through that process. So as opposed to policymakers that don't have to wait on real parties and real disputes, and the parties get to shape the case their way, they get to decide what legal issues they're going to contest, and that narrows what the court can do. So policymakers, if you had, enough agreement to pass something, you could just do it in one day, just enact the law, enact the policy, and that is definitely not how judicial decision-making works.
Well, I know that you have followed the same rule as Justice Ginsburg in not expressing opinions on cases that might come before the court. Is this another practical reason why you can't predict how you will rule in the future? Because you don't know what the facts of that case may be. You don't know what the issues in controversy might be. So how in the world could you sit here and basically tell us about what your policy will be without knowing all of that?
I couldn't, and I think when Justice Ginsburg said it would show disregard for the judicial process and even disregard for litigants, what she was getting at is that it would signal to litigants, listen, all the briefs and stuff you file in a case, that doesn't really matter because judges just have a gut reaction. They just, they know what they think, and this is all just going through the motions. But that's not how the judicial process should work or does work.
There's no reason to believe that a judge's gut reaction is any better than any other American citizen's reaction, is there?
No, and the judicial process, I described this a little bit yesterday, a judge needs to have an open mind every step of the way. So as I said, I've changed my mind at oral argument even after reading the briefs. I've changed my mind at conference after consulting with my colleagues. So if I were to just say how I thought I would resolve a case just because I saw the issue, it would be short-circuiting that whole process through which I should go and have an open mind and be open to persuasion.
Well, I don't see any of the big blow-ups or charts here today about individuals that were the subject of the stories that our Democratic friends were telling yesterday. Maybe we'll see them later. But to me, the idea that some case that you might decide in the future that you have not had a chance to go through this analysis of and predicting how you might rule in the case, is that even possible?
It's not possible because I don't know whether my mind could be changed at some step along the way. And if I did it, I think I said yesterday, I'd be kind of like a legal pundit, just commenting on things in real time. And I don't think anyone wants judges to function that way. They want judges to go through the process, take things seriously, do a lot of research, do a lot of writing, keep an open mind.
And where in the Constitution does it authorize a judge to be a legal pundit and just make policy pronouncements separated from all of these requirements?
Well, Article 3 prohibits it, insofar as Article 3, the court has said, prohibits federal courts from issuing what are called advisory opinions. And that means that when there's no real case in front of you, no real case or controversy, then you can't just offer an advisory opinion that's not the resolution of a case to express your view of the law.
So it's not fair, is it, to suggest that by confirming you to this position, you're somehow going to adversely impact the lives of these individuals?
Well, as I said yesterday, what I can say is that I have certainly no agenda. I'm not on a mission. I'm not hostile to the ACA at all. And if I were on the court and if a case involving the ACA came before me, I would approach it with an open mind, just like I do every case, and go through the process that we've just discussed.
And again, referring back to what Justice Ginsburg said in this New York University Law Review article, if judges restrict themselves to deciding cases or controversies as opposed to making broad policy announcements and displacing legitimate dispute, debate, negotiation, and legislation, does that encourage more litigation and dissension, or does it resolve it?
Well, without commenting on what Justice Ginsburg said about Roe versus Wade in particular.
No, I'm not talking about that. I'm talking about generally speaking.
Just as a general matter, the case or controversy requirement, insofar as it ties the court to the particular litigants and to the particular issue presented in the case. In fact, the Supreme Court has a rule that it will not consider questions outside of the question presented in the case, absent unusual circumstances. And so that means that the court can't reach out and decide other issues that might be in the case if it didn't grant cert on them. And so I think incremental decision-making or a court limiting itself to the issues actually presented is one way that the court tries to respect this constraint on its power, that it's only actually resolving the cases right in front of it.
And getting back to the Declaration of Independence and the source of governmental legitimacy, this structure, these arrangements are not made to benefit you or the courts or to benefit us. They're to benefit the American people by making sure that they are the ones who are the source of political power. Do you agree with that?
All provisions in the Constitution are there to benefit the people.
And so if the court rules on a statute, we can change the statute, but the court says something is unconstitutional, you could amend the Constitution to change that ruling. The people could do that, right?
Yes, they could.
So the American people are the final word.
Yes.
Mr. President, Mr. Chairman.
Thank you. Senator Durbin.
Thanks, Mr. Chairman. Judge Barrett, good to see you again.
Good morning.
Thank you. You're making history. You're the first, I wish the senator from Idaho could hear this, you are the first nominee for a vacancy on the Supreme Court